Good afternoon, everyone, and thank you very much for attending today's Junior Programme Seminar on Litigation. I'm Nick Macklam, and you'll be hearing from me and my colleague James Fagan on two litigation-themed topics. First, I'll take you through my top 10 cases of 2020, and then James will have a look at the illegality defence as refined in two recent Supreme Court decisions. I'll begin by speaking for 25 minutes or so on my top 10 cases, and then I'll hand over to James. If you have any questions as we go through, please type them into the Q&A box and we will do our best to answer them if there's time at the end. Now, 2020 has been a challenging year for all of us, but one of the positives is that it has given us a lot of interesting cases from the Supreme Court, the Court of Appeal, and the High Court. And I thought it would be nice to reflect on some of those in this seminar, which is the last Radcliffe Chambers Junior Programme Seminar of the year. So without further ado, and in no particular order, here are my top 10 cases of 2020. Starting with test claimants in the FII group litigation against HMRC. Now, this was a decision of the Supreme Court given on the 20th of November. It concerns the way in which corporation tax used to be charged on dividends received by UK resident companies from their non-resident subsidiaries. There is, as the Supreme Court put it, a colossal amount of money at stake, which has made it worthwhile for every arguable point to be taken. And that goes some way to explain the extraordinary procedural history. It relates to a group litigation order made 17 years ago. There have been a huge number of judgments, including 3 Chancery Division judgments, 3 Court of Appeal judgments, 3 ECJ judgments, and now 2 Supreme Court judgments. And soon there'll be a third from the Supreme Court, because when I went on the Supreme Court website on Tuesday of this week to prepare for this talk, I saw that there was another hearing in this case taking place that day. Now, in this case, the claimant sought repayment of tax from HMRC on the ground that they'd been taxed in a way that was incompatible with EU law, and they sought repayment of the tax plus interest dating back to 1973. The claim was one in restitution, i.e. based on a mistake of law. The claimant said they'd paid tax on the basis of a mistake that it was lawfully due. And the Supreme Court had to decide how section 32(1)(c) of the Limitation Act applies. Now, this says that an action for relief from the consequences of a mistake, for those actions, a limitation period begins to run when the claimant has discovered the mistake or could, with reasonable diligence, have discovered it. There are 2 important previous decisions of the House of Lords relevant to this. The first is Kleinwort Benson and Lincoln City Council from 1999, and the second is Deutsche Morgan Grenfell and Inland Revenue Commissioners. Now, in Kleinwort Benson, the House of Lords held that section 32(1)(c) applies to mistakes of law, and in Deutsche Morgan Grenfell, the House of Lords tied the discoverability of a mistake of law to the date when the truth as to whether the claimant has a well-founded cause of action is established by a court of final jurisdiction. So in other words, whether the claimant has a valid cause of action isn't discovered until after the claim succeeds before a court of final jurisdiction. And in FII, the correctness of those judgments was challenged by HMRC. Now, the majority of the Supreme Court overruled Deutsche Morgan Grenfell, but it left Kleinwort Benson alone. So it held that section 32(1)(c) does apply to claims for the restitution of money paid under a mistake of law, but it decided that time begins to run when the claimant discovers, or could with reasonable diligence have discovered, their mistake in the sense of recognizing that they have a worthwhile claim. Now, there was a dissenting opinion, which was that section 32(1)(c) doesn't apply to mistakes of law, so the dissent would have overruled Kleinwort Benson. So that's what the Supreme Court decided back in November. And the next steps are that there will be yet another hearing in the High Court after pleadings have been amended to try and work out how the Supreme Court's new test is to be applied. Turning to my second case, this is a decision of the Supreme Court given on the 6th of November. It's the first ever decision of either the Supreme Court or the House of Lords on section 84 of the Law of Property Act, which gives the upper tribunal the power to discharge or modify restrictive covenants. The facts were that a property developer built 13 units of affordable housing on land in breach of restrictive covenants, and a charitable children's cancer trust had the benefit of the restricting covenants. The question was whether the developer's application to discharge or modify the covenants after the housing had been built should succeed. The upper tribunal decided that the covenants should be modified to allow the use of the land for the new housing units subject to compensation to the trust. The Court of Appeal overturned that and held that the covenants should not be modified. And a key question in this case was the weight to be given to the developer's deliberate and cynical breach of the covenants. The Supreme Court held that there is a two-stage test for exercising the Section 84 power. There's first a jurisdictional stage, are the relevant conditions met? And there's secondly a discretionary stage. And the Supreme Court held, contrary to what the Court of Appeal had said, that the deliberate and cynical breach was relevant to the discretionary stage, but not to the jurisdiction stage. However, it agreed with the Court of Appeal that the covenants should not be modified. It said that the case raised a fundamental dilemma over the use of land. The developer wanted to ensure that 13 new affordable homes didn't go to waste, but on the other hand, a charitable children's trust wished to ensure that the terminally ill children in a hospice could enjoy in privacy the use of the hospice's grounds without being overlooked by the new homes. So on the facts of this case, the Supreme Court held that the first stage of the exercise of the Section 84 power was satisfied, but it held that the second stage of the test, the discretion, was not satisfied. It said that the UT had made two material errors of law in failing to take account of the fact that first, there was other land that the developer could have built the homes on, which were not encumbered by the restricted covenants. And secondly, the developer would have been unlikely to satisfy the Section 84 test if it had made its application to modify or discharge the covenants before it had built the homes. So it had cynically breached the covenants and presented the upper tribunal with a fait accompli. So on the very strong facts of this case, the Supreme Court held that something had gone fundamentally wrong with the UT's exercise of its discretion. It should have declined to modify or discharge the covenants. Case number 3, Letimarchi and Cooper. This is a decision of the Supreme Court given in July 2020, and it concerned a charitable company with investments in the region of £4 billion, with a board of directors and 3 members. 2 of the 3 members were a married couple. Sadly, their relationship broke down and they divorced. And that affected the charity because the former spouses, who were directors, couldn't agree on how the charity should be operated. So they agreed a compromise as part of their divorce that the wife would resign from the charity as a director and member, and in return, the charity would make a $360 million grant to a new charity which had been founded by her. Because the grant was to be made in connection with the wife's resignation as a director, it needed to be approved by a resolution of the members. Both the husband and the wife were conflicted, so that left only one member to vote on it, Dr. Letimarchi. The problem was that he was concerned about whether he could vote in favour of it. The matter came before the court on the application of the trustees of the charity, who surrendered their discretion to the court to decide whether to proceed with the compromise and to make the grant. And there were essentially 3 questions. Question number 1, was the sole member who could vote on the resolution to approve the grant a fiduciary? Question 2, if he was, could a fiduciary in principle be compelled to vote in favour of a resolution? And question number 3, if yes, was that conclusion affected by Section 217 of the Companies Act, which concerns payments by a company to a director on the loss of that director's office? Now, to those 3 questions, the Supreme Court gave the following answers. On question number 1, was the member a fiduciary? The court answered that question with quite a specific focus. It held that Dr. Letimarchi, as a member of a charitable company, owed fiduciary duties to the charity's purposes when deciding how to vote on the resolution. Now that has potentially wide-ranging implications for big charities which have lots of members. In relation to question 2, whether he could be in principle compelled to vote in favour of the resolution, the Supreme Court held that the answer to that was yes, if the court decides that the transaction would be in the charity's best interest, as it had here. The charity's fiduciaries are obliged to ensure that the court's decision in that regard is implemented. And in relation to question 3, the court held that that conclusion was not affected by Section 217 of the Companies Act. Now, if you're interested in reading more on this case, there's a very good article by my colleague Matthew Mills on this judgment, which is available on the Radcliffe James website. Case number 4, Morrison's Supermarkets and Various Claimants. This is a Supreme Court decision of April 2020. An employee of Morrison's was supposed to transmit payroll data relating to all of Morrison's employees to its external auditors. And when he did so, he took a copy of the data himself and he uploaded it onto the internet. Then he sent the file anonymously to 3 newspapers. He was eventually arrested, tried, and imprisoned. The claimants were various affected employees. They claimed for breach of statutory duty under the Data Protection Act, for misuse of private information, and for breach of confidence. The claim succeeded at first instance on the basis that Morrison's were vicariously liable for their employees' acts. The Court of Appeal upheld that decision, but the Supreme Court overruled it. And that was on the basis that, firstly, the online disclosure of the data by the disgruntled employee was not part of the employee's field of activities. He wasn't authorised to do it. Secondly, the close connection test was not satisfied simply by reference to the temporal or causal connection which existed in this case. And thirdly, the court was greatly influenced by the fact that the employee was acting for purely personal reasons. Case number 5, Fern and the Board of Trustees of the Tate Gallery. This is a decision of the Court of Appeal. It concerned the law of nuisance and its application to overlooking from one property to another and invasion of privacy. The claim had been brought by the owners of a building next to the Tate Modern for an injunction to prevent people from looking into their flats from the Tate's viewing gallery. The judge dismissed the claim in the first instance. He decided that as a matter of principle, a nuisance can be caused by overlooking, and that the common law is capable of protecting privacy rights through the tort of nuisance. And he said that even if that was doubtful before the Human Rights Act, Article 8 has removed any doubt by developing the common law. But he held that there was no actionable nuisance in the present case because the claimants lived in central London, they'd chosen to buy the flats in question and create or submit themselves to an increased sensitivity to privacy, and there were reasonable steps that the claimants could take to deal with the overlooking, such as installing blinds and so on. The Court of Appeal agreed that there was no actionable nuisance, but for different reasons. Importantly, it held that there is no cause of action in private nuisance for overlooking. The court noted that it would be difficult to apply the test for nuisance to overlooking, which requires consideration of whether there's been a material interference with the amenity value of the land. And it said that when considering whether to develop the common law, it was relevant to look at other means of protecting individuals. And in that regard, the court noted that there are already various laws that exist to deal with overlooking, particularly planning law. So the court considered that it ought to be left to Parliament to formulate any further laws to deal with overlooking rather than extend the law of private nuisance. And it also held that there was no sound reason to extend the common law tort of private nuisance to overlooking in the light of Article 8. So as a result, the appeal was dismissed, but for different reasons. The next case is Pease and Carter. This is another judgment of the Court of Appeal. It concerns notices of proceedings for possession served under Section 8 of the Housing Act. And the issue in the case was whether the notices that had been served were invalid because they contained an obvious typographical error. So they said that proceedings would not begin after the 26th of November 2017, when 2018 was intended. And the question in this case was whether the approach to unilateral notices set out in Manai Investment Co Limited and Eagle Star Assurance should be applied to Section 8 notices, i.e., should the notice be interpreted as it would be understood by a reasonable recipient reading it in context. Now, I imagine to the relief of the solicitors in this case, the court held that the Manai approach should be applied. It said that if a reasonable recipient would appreciate that the notice contained an error and would appreciate what meaning the notice was intended to convey, then that is how the notice is to be interpreted. And as such, the court held that as long as the notice construed in accordance with Manai was substantially to the same effect as the prescribed form, it was valid, and it upheld the notices in this case. Case number 7, Attorney General and Zedra Financial Services UK Limited. This is a High Court case. It concerned the National Fund, which is a charity set up in 1928 by an anonymous donor of £500,000 with the aim of investing and accumulating the income of the fund until it and other donations would be large enough to pay off the national debt. Now, that fund has since grown to some £512 million. Sadly, despite that growth, the expert evidence was that the likelihood of it ever being sufficient to discharge the national debt is vanishingly small. And in those circumstances, the question for the court was whether to release the fund to the National Debt Commissioners, or whether, as the heirs of the now not anonymous donor contended, the trust was invalid and the money was held on a resulting trust for the donor's estate. Now, the court held that the fund is held on a valid charitable trust and that it has jurisdiction to alter the terms of the trust to enable it to be distributed in advance of the time specified by the donor. However, the court was not satisfied on the basis of the current evidence that releasing the fund to pay down effectively a fraction of the national debt, a very small fraction, wasn't satisfied that that is the most appropriate use of the funds on the evidence as it stood. And accordingly, the destination of the fund will be decided after a further hearing. Case number 8 is Marek's Financial Limited. This is a Supreme Court case. The judgment was given on the 15th of July of this year. And the facts were these. After a draft judgment at first instance was circulated, which awarded Marek's judgment against 2 companies, the owner of those companies promptly stripped those companies of all their assets by transferring almost $10 million into his personal control. Marek's brought a claim against the owner of the companies, seeking the judgment debt awarded against the companies, plus their costs of seeking to obtain payment. The owner sought to challenge the court's jurisdiction, and in doing so, he argued that the rule against reflective loss precluded Marek from having a claim. The Court of Appeal accepted that argument, but it was overturned by the Supreme Court. Now, it held that Prudential Assurance Co. and Newman Industries Limited had laid down a rule of company law that diminution in the value of a shareholding, which is the result of loss done to a company by a wrongdoer, is not separate and distinct damage to that suffered by the company, and therefore is not recoverable. In Johnson and Gore Wood, the Supreme Court said that Lord Bingham had correctly understood that. However, in other speeches, particularly the speech of Lord Millett, that principle had been misunderstood as being one based in the law of damages, which aims to avoid double recovery. And the Supreme Court said that this had resulted in the expansion of the principle into difficult areas, including cases such as the present, where a creditor of a company suffers substantially the same loss as the company when the company's assets have been stripped. The Supreme Court held that the reflective loss principle should be confined to cases where claims are brought by a shareholder in respect of loss suffered in that capacity, which is the consequence of loss sustained by the company. Accordingly, it decided that part of the reasoning in Johnson and Gore Wood was wrong and should be departed from, and that as a result, a host of other cases had been wrongly decided, and those cases are listed on the third bullet point in the slide. So in the present case, that meant that the reflective loss principle did not apply to Marek's claim. There was a dissent. Lord Sales would have gone further and got rid of the rule against reflective loss altogether. Case number 9 is the case of Duval. It's a judgment of the Supreme Court given in May 2020, and it's a property law case concerning enforcement of leasehold covenants. It concerned a building which had been converted into 9 flats. The leases were typical, one sees them all the time. Each lease included a provision that, on request by the tenant, the landlord would, on certain conditions, take action against other tenants in the building for breach of covenant. Now, in this case, a tenant wanted to carry out works which involved removing a wall. That would have breached a covenant in her lease. She asked the landlord to consent to those works by granting her a license to do them. The landlord was minded to grant a license, allowing her to do those works. But another tenant in the building argued that if the landlord did that, the landlord would be in breach of the obligations owed to her under her lease. So the court had to decide whether the grant of a license to tenant A to allow her to do the works would breach the landlord's obligations to tenant B, and the Supreme Court held that it would. That was because the landlord had assumed a conditional obligation to B to take action on certain conditions if A breached the covenant in her lease, and there was an implied term that the landlord would not take action to prevent the contingency from occurring. So in other words, the landlord would be in breach of that implied term if it consented to the works before tenant B had a chance to object and request that the landlord take action against tenant A to enforce the covenant. That's an important decision because it has potentially quite wide-ranging ramifications, given that these leases are extremely common. So landlords of blocks of flats who had previously been minded to consent to a tenant's request to do something in breach of covenant will have to be careful, because otherwise they may find themselves in breach of all the other leases in the building. Now, case number 10 is Stoffel and Henderson, and these are decisions of the Supreme Court which concern the illegality defense after Patel and Mirza, and these cases are the subject of James's talk. So without further ado, I will hand over to James to talk you through them.
Thank you. So my name's James Fagan. I'm the most junior tenant at Radcliffe Chambers now, and I'll be speaking to you about those 2 recent decisions in the Supreme Court concerning the illegality defense. My talk's going to be broken into 4 sections. The first, I'm just going to briefly look at the history of the illegality defense so that we can understand where it came from and what the problems were that resulted in Patel and Mirza. I'll then go on to look at the 2 cases that came out in October this year, Stoffel Co, Grondona, and Henderson and Dorset Healthcare University NHS Trust, before leaving you with a few key takeaways that you should take from those decisions. So the illegality defense has existed within the common law for several hundred years. A rather clear exposition of it can be found in Lord Mansfield's speech in Holman and Johnson in 1775, where he stated that no court will lend its aid to a man who founds his cause of action upon an immoral or an illegal act. You may sometimes hear the phrase ex turpi causa, which in Latin means from an immoral act. I prefer to stick with the rather clear and obvious statement of the illegality defense, and that's what I'll refer to throughout this talk. The illegality defense is versatile because it can apply in pretty much all civil claims, whether they relate to contract, property, tort, or unjust enrichment. And so they're very important. It's a very important tool for litigators, particularly those who might be involved in fraud cases. However, its development has not been easy, and in particular, it's faced difficulties in the past 30 years. A number of those difficulties can be traced back to the House of Lords decision in Tinsley and Milligan in 1994. I'm not going to go into the facts of this case, other to say that this was a property case, and the House of Lords decision focused on the so-called reliance principle, which is that the illegality defence will succeed where a claimant must rely on the illegality to establish their claim. And what Lord Brown Wilkinson said of this is that the effect of illegality is not substantive, but procedural. And this was subject to significant criticism. The Law Commission published 2 consultation papers in 1999 and 2009, and a final report in 2010 that described the illegality defence as being complex, uncertain, arbitrary, and opaque. The arbitrariness came from the fact that the principle was ignoring the merits of the cases in which it was raised, being focused solely on a procedural, does the claimant rely on the illegality to establish their case? The uncertainty came from confusion as to what was meant by reliance. There was injustice being risked because the procedural focus precluded attention and examination of the underlying policies. And the overall result was a rather unclear and opaque rule that was very difficult to apply. And so between 2014 and 2016, the Supreme Court decided 3 cases concerning the illegality defence, where they tried to tussle with this reliance principle. And ultimately, this led to a 4th decision being heard in the Supreme Court, Patel and Mirza, which amounts to a significant restatement of the common law. Essentially, it rejected the reliance principle in favour of a flexible, policy-based approach. And this approach focused on an underlying policy consideration that in order to reach a balanced judgment, you must take into account the proportionality of the outcome with reference to those underlying policies. And central to that approach is one question: would enforcing the claim lead to an inconsistency that would damage the integrity of the legal system? And this is a 3-stage assessment. First, the court will look at the underlying purpose of the illegality in question and whether that purpose would be enhanced by denying the claim. Second, it would look at any relevant public policy which might be affected by denying the claim. You might see this referred to in judgments now as what are the countervailing policy considerations in favour of allowing the claim to proceed. And the third area of assessment is whether denying the claim would in fact be a proportionate response to the illegality in question. So, having set this out, the illegality defence has been allowed to proceed under a new framework. And it wasn't until this year that it returned to the Supreme Court in 2 cases where the Supreme Court has had the opportunity to further examine what was set out by Lord Toulson in Patel and Mirza. The first is a professional negligence claim, Stoffel Co and Grondona. The facts were as follows. Miss Grondona had a business relationship with a Mr. Mitchell. In short, that relationship was one where Miss Grondona would have mortgage agreements in her name. Mr. Mitchell would manage properties, and she would receive a cut of the profits when those properties were sold. In 2002, Miss Grondona brought a property from Mr. Mitchell with the assistance of a mortgage from Birmingham Midshires, which would secure the mortgage on that property. However, the mortgage advance was procured by fraud. The ultimate purpose was to raise capital for Mr. Mitchell, which he would otherwise be unable to obtain from a high street lender. In essence, what Miss Grondona did is she misrepresented to Birmingham Midshires that the sale was not a private sale, that the deposit monies were from her own resources, and that she was managing the property herself, which of course did not comport with the true purposes for which she was getting the mortgage. She instructed, along with Mr. Mitchell and Birmingham Midshires, the solicitor's firm Stoffel Co. Unfortunately, Stoffel Co negligently failed to register, in particular, the form TR1 at the land registry, which would transfer the legal title from Mr. Mitchell to Miss Grondona. The consequence meant that Birmingham Midshires were unable to look to the property to recover the amount lent following a default on repayments by Miss Grondona. And but for Stoffel's negligence, the property would have been otherwise unencumbered and could have been sold to meet the claim of Birmingham Midshires. Stoffel Co were added to the litigation as Part 20 co-defendants in an attempt to obtain a contribution from them. They attempted to rely on the illegality defense, pointing to the illegal mortgage fraud that Miss Grondona had taken part in. Interestingly, this case was first decided at first instance under the Tinsley and Milligan reliance principle, and it was held that the illegality defense did not apply. By the time it worked its way to the Court of Appeal, Patel and Mirza had been decided, and so the illegality defense fell to be determined by that. And so on appeal, the only ground which was given permission to be heard by the Supreme Court was on the fourth ground, namely whether the Court of Appeal had correctly applied the decision in Patel. The unanimous decision of the court in Stoffel Co was given by Lord Lloyd Jones. What he noted was that the illegality defense rests on two broad policy considerations in support of one overarching goal. The considerations are that a person should not be allowed to profit from their own wrongdoing, and the second is that the law should not be self-defeating, condoning illegality by giving with the left hand what it takes with the right. And what those policy considerations are supporting is this idea of the integrity of the law, that it should not be seemingly having different outcomes, condemning different things in one branch while allowing them in another. Turning to the trio of considerations that were set out in Patel and Mirza, these aren't in the form of a three-stage test. They're not to be applied mechanistically. I suppose the danger is that where you have a case that sets out, here are the three things the court will look at, a lot of litigants and lawyers will think, great, if I simply answer them yes, 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 going through, I will get the correct answer. That's not what the illegality defense after Patel and Mirza is trying to do. Instead, it's considerations A and B, which are the policy considerations, are to be considered at a general level and at a high level. And what you're not engaging in the court is a policy consideration about which policy is effective in its goals. The court is not going to direct evidence about whether the criminal law is effective or what the social consequences of a given policy are. The question at all times is the integrity of the legal system, and that doesn't require an evaluation of the policies in and of themselves, but whether to permit a claim to proceed would be inconsistent with those policies. And what Lord Lloyd Jones also noted is that proportionality may not fall to be considered in every case. If it becomes incredibly clear at stages A or B that the answer is clearly in favor of the claim proceeding or against the claim proceeding, then it may not be necessary to go further and see whether to deny the claim would in fact be disproportionate. And specifically, if the policy points to disallowing the defence, there's never going to be a risk of disproportionate harm because it's going to be allowed. So turning to the facts of the case at hand, Lord Lloyd Jones noted that deterrence for mortgage fraud is one policy of the criminal law, as is protection of the public. But in the present case, there was no risk of either of those policies being undermined. What the appellants had attempted to argue was that the law seeks to deter mortgage fraud from being a serious offence. But in Lord Lloyd Jones' opinion, the risk of being left without a remedy if their solicitor was negligent would be unlikely to feature in the thinking of a fraudster. It's an entirely separate matter, and that while protection of the public is important, denying a remedy in this case would not in fact further that aim, because the registration of the property transfer was not a necessary step in perpetrating the fraud. The fraud was complete by the time Stoffel Co came to fill out the TR1 and send it to the land registry. And actually, on the contrary, the failure to register the charge would result in harm to the victim bank, Birmingham Midshires, because they would no longer have the benefit of security for their mortgage advance. And so actually having solicitors carry out their job and registering property ownership at the land registry actually furthers one of the aims of protecting the public. And turning to the countervailing policies, the solicitors should perform their duties diligently and free of negligence, and that those who use their services should be entitled to a civil remedy for losses suffered, and that to deny the remedy in this case would be counter to those policies. Lord Lloyd-Jones observed that it would be more likely that a fraud would be prevented if solicitors appreciate that they should be alive to and question any irregularities in a particular matter that they are instructed on. And indeed, he noted that a closer examination of the facts of this case would have put Stoffel on notice of the possibility of fraud, not least the relationship between Miss Grondona and Mr. Henderson. And so simply denying this negligence claim would not have furthered the aim of protecting people from the negligence of solicitors, whereas allowing it means that solicitors are more likely to internalize the lessons that if they're negligent, there will be consequences. So in those clear circumstances, and then there was another point, which is one that's not widely reported when you read articles about this case, which is that Miss Grondona was entitled to an equitable interest in the property because every step to register was taken. Both Tinsley and Milligan and Tell are authorities for the proposition that where property is transferred for an illegal purpose, the transferee obtains good title in both law and in equity, notwithstanding that the transaction being illegal would not have been specifically enforced. So where you had the intentions of Miss Grondona, Mr. Mitchell and Birmingham Midshires being that Miss Grondona should have legal title to the property and Birmingham Midshires the benefit of the charge, everything to do that had taken place. And so Miss Grondona had an equitable interest, and it would be inconsistent with the law to accept that the equitable interest had passed to her while refusing to permit proceedings against a third party for failing to protect that interest by registering the TR1 at the land registry. And so in those circumstances, it was not necessary to look at the question of proportionality, but the court went on to do so. And what Lord Lloyd-Jones expressly noted was that the claim could be established without reference to the illegality. So the fraud was not central to the claim in this case. And that, while it was necessary to instruct the solicitor to maintain the dishonest pretense, that was merely part of the background of the case. And that the alleged breach focused on the failure to register title and how the finance to obtain that title was procured was irrelevant to that obligation. So turning to the second case, this is the Henderson case, which exists in a background of clinical negligence and some rather tragic facts. Miss Henderson suffers from severe psychiatric problems, and in August 2010 was under the care of a community mental health team managed by the Respondent Trust. Following a deterioration in her condition, she suffered a serious psychotic episode and unfortunately killed her mother. She was convicted of manslaughter by reason of diminished responsibility and was sentenced to a hospital order under the Mental Health Act 1983. And it's important to note that that type of hospital order she was subjected to is expressly not a penal order. Ms. Henderson, through her litigation friend, the official solicitor, brought a negligence claim for damages against the respondent, who admitted that they had negligently failed to return Ms. Henderson to the hospital when her psychiatric condition deteriorated, and had it done so, the killing would not have taken place. However, what the NHS Trust tried to do is rely on the illegality defense, stating that the damages that were being claimed by Ms. Henderson arose from her criminal sentence and or her criminal act. In a previous case in 2009, the House of Lords had held that similar claims to Miss Henderson's were irrecoverable, and the case in question was Grey and Thames Trains Limited. Miss Henderson argued that the Supreme Court should distinguish Grey or depart from it. The facts of Grey can be briefly stated. Mr. Grey was a passenger on a train and had suffered an accident which left him with severe PTSD. And while suffering from symptoms of that condition, he unfortunately killed a man. He pleaded guilty to manslaughter on the grounds of diminished responsibility and was ordered to be detained pursuant to a hospital order. He brought an action in negligence against the rail company, seeking damages for his detention, loss of earnings, for the psychological impact of the killing, and also an indemnity. The House of Lords held that the claims were precluded by operation of the illegality defense. What was attempted to be relied on by Miss Henderson in her case were a statement in the judgment of Lord Phillips, where he expressed reservations that the illegality defense might not apply where a defendant did not bear significant personal responsibility for the crime which amounts to the illegality, or in circumstances where the illegality arises from strict liability, in circumstances where the guilty party does not have any knowledge of the facts giving rise to their liability. Miss Henderson argued that Grey could be distinguished based on this reservation. The sentencing judge in her case found that she did not bear a significant degree of responsibility for what she had done. But Lord Hamblin, giving the Supreme Court's decision in Henderson's case, noted that in Grey, the majority's reasoning was that the emphasis they placed was not focused on the degree of responsibility, but simply on the existence or finding of criminal responsibility. And that was a crucial consideration. There was no attempt by their lordships in Grey and Thames Trains to determine to what extent diminished responsibility results in a lesser degree of responsibility. It's simply, once you were found criminally responsible, the court would not descend further into it. And therefore, Grey could not be distinguished, and that the majority's reasoning in that case applied regardless of the degree of personal responsibility. So turning to the next strand of the appeal, Miss Henderson sought for the Supreme Court to depart from Grey pursuant to the 1966 practice statement, which allows the Supreme Court to depart from previous decisions of the House of Lords or the Supreme Court. Lord Hamblin noted that this presents a very high hurdle to appellants in order to convince us or persuade the Supreme Court to depart from earlier decisions. What Lord Hamblin noted was that the decision in Grey was consistent with Patel. It was one where Lords Hoffman and Lord Roger considered the policy reasons against recovery and did not merely focus on the reliance principle. In Patel, Lord Toulson had noted that Grey had been a decision based on policy rather than reliance. And in Henderson, Lord Hamblin noted that the policy identified in Grey was the need to maintain the integrity of the legal system. Another argument advanced was that Grey should be confined to cases where there was a degree of personal responsibility. But what Lord Hamblin noted was that the civil law the arguments presented, while persuasive, ultimately did not succeed. Because what Miss Henderson was arguing, the civil law approached issues of responsibility differently, focusing on capacity, and that the lack of a penal sentence when a hospital order is made means that a denial of the claim would amount to the civil law imposing a punishment when the criminal law opted not to. However, ultimately, what Lord Hamblin noted was what diminished responsibility does is that it's not saying that there was no responsibility on the wrongdoer, it's that their responsibility was diminished. That is the distinction between diminished responsibility conviction and a finding of not guilty by reason of insanity under the McNaughton rule. So in this case, to allow recovery would attribute responsibility not to the criminal as found by the criminal law, but to the tortfeasor, thereby making the criminal law the criminal under the criminal law, the victim under the tort law. And so the final point then was turning to Patel, whether Gray was consistent with that form of policy assessment. So under the first consideration, the policies engaged included the gravity of the offence, the public interest in the allocation of NHS funds, the connection between the claim and the offence, and deterrence, protecting the public, and condemning unlawful killings. What's notable here is that Lord Hamlin said that the gravity of the offence and the significance of the public interest in the allocation of NHS funds heightened the public confidence considerations in the application of the illegality defense. And what this is likely to mean, therefore, in practice, is that where you have very serious crimes, that will strengthen the importance of the policy underlying the illegality at the first stage against countervailing policies at the second stage. Furthermore, as we see, this is another case where the court noted the very close connection between the crime and the claim being brought. In this case, the crime was the effective cause of the loss to Miss Henderson. And on the deterrence point, while it was noted that there was some force in saying that a denial might not deter those with diminished responsibility, Lord Hamlin looked more broadly and stated that there may well be a deterrent effect in a clear rule that unlawful killing never pays, and any effect is important to give power to the fundamental importance of the right to life. We can contrast that to Lord Lloyd Jones, where he, in the Stoffel case, had said that the fact that it's not likely to enter into the mind of fraudsters, this deterrence effect, is a relevant point against denying the claim. So it appears that where you have a more grave or significant illegality, you're more likely to accept, the court will be more likely to accept a wider policy consideration, and even if the likelihood of that in practice having the desired effect is low. And turning to the countervailing policies that were advanced by Ms. Henderson, these just did not defeat the policies engaged by the illegality. The identified policies included encouraging the NHS to care competently for the most vulnerable. What Lord Hamlin accepted that limiting cases is unlikely to affect the exercise of due care, and that NHS staff are unlikely to need any encouragement to try and do their best to stop patients from killing people. The policy of compensating victims of torts where they're not responsible for their conduct was not a clear policy, despite the efforts of counsel for Ms. Henderson. That a policy that public bodies should pay compensation to those whom they injure falls short, because it begs the question, because it assumes that the injury is caused by the respondent's negligence rather than the appellant's own criminal act. And the fourth consideration or policy that was put forward was that criminals should receive proportionate sentences. But to deny claims is consistent with that point made that the law should not give with one hand what it takes with another. Again, this was a case where proportionality did not fall to be expressly considered, but was looked at none the same. What Lord Hamlin noted was that the seriousness of the crime, the centrality of the illegality to the claim being brought, the intention of wrongdoing on the criminal party, and the disparity in wrongdoing between the person committing the illegal act and the respondent in tort, all came together to point against a conclusion that the denial of the claim would be disproportionate. So, where do we find ourselves after these two cases? Well, the first point I'd say is that Patel worked. As an approach to determining illegality and whether that defense should apply, It doesn't require trivial distinctions or judicial acrobatics. It's unabashedly focused on policy and clearly stated considerations, and it results in decisions which are clear and contain understandable reasoning. Secondly, we now are clear as well that the considerations set out by Lord Toulson are not a three-stage test, and anyone faced with the illegality defense should not approach it like a negligence or an estoppel three-stage test. It's evaluative, it's high level, and even though it's about identifying policies, they're generally going to fall into some recurring camps. So there'll be issues about the deterring of the criminal behaviour, encouraging another form of behaviour, so preventing crime, compensating victims for wrongs, things like that. And what I think Henderson shows us is that a wide variety of policies may come into play, such as the allocation of public funds to those found guilty of a criminal offence. What is likely to be of a bit of joy to solicitors is that Grondona is not likely to benefit fraudsters. While we can expect that there may be an imminent rise in fraud-related claims because of COVID-19 and the well-reported fraudulent attempts to take advantage of the furloughs or the tax holidays, the court noted in Grondona that there was a lack of any profit in that case. Ultimately, the damages being sought represented the indebtedness to Birmingham Midshires. And so that lack of profit in those facts should be a bar to a wider application of Grondona. But I wonder whether the Supreme Court could have gone slightly further in its reasoning in Grondona. As I said in Henderson, there was a much more general attempt to understand the policies against unlawful killing, and that while there was a lack of deterrence, the fact that it may deter even a small amount of potential criminals is sufficient for upholding that policy. And so when Lord Lloyd-Jones says it's unlikely to deter anyone, perhaps he should have gone on to consider, well, is it a good thing to take a very strict line on mortgage fraud if it deters even a small number of cases? Henderson has not shut the door on triviality. The examples referred to in Lord Phillips's speech have not been completely shut down, thrown out, but they're likely to only arise in the most exceptional cases. And they reflect the fact that the illegality defense now is a flexible doctrine. It's not one that's mechanistically applied. There's always going to be some room on its boundaries for more difficult, finely balanced cases. What we also now know is that pre-Patel case law is relevant. Gray was essentially on all fours with Henderson. I think that the key to knowing whether a pre-Patel case is binding will be the extent to which it is based on the reliance principle, at which point it's unlikely to really be of a system, or is a case where the policy consideration about the integrity of the legal system were at the forefront of the judicial exercise. But even if a case is reliance focused, it might be that it contains some useful judicial statements on the competing policies in relation to that given illegality. I think that will be useful to anyone facing a similar case. And finally, I question whether we are seeing the introduction of what I call reliance principle 2. As was clear in both Stoffel and in Henderson, both Lord Lloyd-Jones and Lord Hamblin made reference to the centrality of the illegality on the claim being brought. And while that normally might be seen at the proportionality stage, it did seep into the considerations at the policy stage in considerations A and B under Patel. And so I wonder whether it's going to still be necessary for lawyers when making the defense or seeking to put aside the defense to really focus on whether the criminality is central to the claim being brought. But hopefully this doesn't result in a full return to the reliance principle. And that is the end of my talk on this topic. So I would like to thank you all for joining us today. I hope you found Nick and I's talks interesting and helpful. This is the last junior program that Radcliffe Chambers will be doing in 2020. So for all of you who have taken the time during this year to join members of Chambers, we'd like to thank you. Junior program will return in 2021. And I would like to say to all of you, I hope you have a very safe and happy Christmas period and Happy New Year.